Jefferson County Court at Law number 2 is now in session with our motion to revoke probation docket and our announcement docket. First case that we're going to call on the motion to revoke probation docket we have two cases, cause numbers 317692 and cause number 317694. Both cases are styled the state of Texas versus Keith Douglas Teague. Mr. Teague, would you please come forward? Mr. Teague, would you please come forward a bit up here? Well, for the record, your name is Keith Douglas Teague.
Yes, sir.
How you doing, Mr. Teague?
Doing all right. How about yourself?
I'm doing fine. Thanks for asking. Mr. Teague, the state is here represented by Attorney Tommy Coleman. Attorney Coleman, how are you doing?
Good job.
And the probation office is represented by Mr. Garrett Gilliam. Mr. Gilliam, how are you doing?
Thank you, sir. Very good.
Now, Mr. Teague, have you been to court before on your motion to revoke probation?
Yes, sir. It's the first time.
Okay. Okay, now, Mr. Teague, I have before me in clause number 317692, a motion to revoke unadjudicated probation that was filed by the Jefferson County District Attorney's Office. This motion, Mr. Teague, alleged that you, Keith Douglas Teague, was tried in County Court at Law number 2 of Jefferson County, Texas, on May 8 of 2018 for the offense of unlawfully carrying a weapon. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for this offense. However, you were placed on unadjudicated probation for a period of 6 months. In this motion, there are 3 allegations. Now, if one of these allegations is found to be true, your unadjudicated probation can be revoked and you can receive, in this case, up to 1 year in the Jefferson County Jail. Do you understand that?
Is it per charge?
I'm on 1 charge right now, on this charge, unlawfully carrying a weapon. Do you understand that?
Yes, sir.
Now, the next case, Mr. T, is cause number 317694. Mr. T, you need to stand up.
Sorry about that.
All right. Now, Mr. T, in this case, I have before me a motion to revoke unadjudicated probation that was filed by the Jefferson County District Attorney's Office on February 27 of 2019. In this motion, Mr. T, it alleges that you, Keith Douglas T, was tried in County Court at Law number 2 of Jefferson County, Texas on May 8th of 2018 for the offense of possession of marijuana, which is a Class B misdemeanor.
Yes, sir.
The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for this offense. However, you were placed on unadjudicated probation for a period of 6 months. In this motion that has been filed by the Jefferson County District Attorney's Office, there's also 3 allegations in this motion. Now, if the court finds that one of these allegations is true, in this case, you can receive up to 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now, Mr. T, there's a document that you have before you that was handed to you, that was placed in front of you by the bailiff. And that document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you see that document?
Sir.
I will go over this document with you. Now, you have a right to have an attorney. And this document states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Do you understand that option?
Yes, sir.
Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number 3, you may represent yourself. Do you understand that option?
Yes, sir.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case or hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney in this case, or in these cases, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in these cases, then you would have placed your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line that is titled defendant, and you will place today's date on the line that states date, and today's date is July 1st of 2022. Mr. T, do you understand?
Yes, sir.
Okay, do you have a pen?
Yes, sir.
Okay, you can go ahead on and make your choice.
So, if you don't mind me asking, so at this moment, I'm looking at, up to a year on unlawful carry and up to 180 days on the possession charge.
If the court finds that you have violated your probation.
And at any time I can change my mind if I want an attorney, right?
If you, okay. The last part now, if they said, if you choose to proceed without an attorney,
Yes, sir.
you may change your mind at any time and may request counsel from the court.
Okay, so it's not an attorney, it's just counsel.
The counsel is an attorney. They're interchangeable.
Okay.
The words are interchangeable.
Yes, sir. Well, I mean, I don't want to screw myself in this, so. I guess I'll just go ahead and, all right.
Okay, now, he has to, there's a waiver. Now, Mr. T, on the document that you just signed, you initialed on the line, said you want to waive your right to an attorney to represent yourself. Is that correct?
At the time being.
Yes, okay. Now, you've just been handed another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I will also go over this document, which in it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this first day of July 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that's your charge, you will sign on the line that says defendant, and you will place today's date, July 1st of 2022. Okay, now, Mr. T,
Yes, sir.
prior to signing, I have these two documents before me, the judge's explanation of rights to defendants without an attorney, and the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Now, do you see your initials on this document and your signature? And do you see your signature on this document?
Yes, sir.
Now, prior to signing and initialing these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything true and correct in these documents? Okay. Now, Mr. T, have a seat, and you'll be able to talk to the prosecutor when the prosecutor is available. So just have a seat.
Sir.
Okay.
It's a restitution problem or issue that can be resolved.
Okay. Court is in session in cause number 330-464. Case is style of state of Texas versus Kenneth Trevon Banks. Mr. Banks is on Zoom. Mr. Banks, you can take your mic off of mute.
Yes, sir.
Mr. Banks, how are you doing?
I'm pretty good.
That's good. Mr. Banks, you're here represented by your attorney, Attorney Tom Burbank. Attorney Burbank, how are you doing?
I'm doing fine, Your Honor.
Mr. Burbank, what is your announcement in Mr. Banks' case?
Your Honor, I've talked to the prosecutor, I've talked to my client, and there has been an offer for restitution. We just have to verify the restitution, and this will be dispositive of the case. And I can talk to Mr. Banks about getting me the money for this all to go away.
Okay, how much time do y'all need?
45 days.
45? Okay, give us a reset.
And it would, I don't need a trial, I just need a disposition date.
Give us a plea date.
It could be September 23rd.
Is that good for you? September 23rd? Okay.
September?
Yes.
My time is going by fast.
Okay, case is reset to September 23rd of 2022. Mr. Burbank, you can get your reset, and I think this is the last case.
No, Your Honor.
You have another? Okay.
I don't know.
And Mr. Banks, your attorney,
Yes,
Mr.
sir.
Burbank, and your bondsman will be given notice of your reset. Your case has been reset to September 23rd, 2022. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Thank you. You too.
All right, you're welcome. Next case is cause number 328902. Case is style of State of Texas versus Tom Bernard. It's John Willis Bernard. Mr. Bernard, is that your full name? How you doing, Mr. Bernard? I'm doing fine. Thanks for asking. Mr. Bernard, you're here represented by your attorney, Mr. Tom Burbank. Mr. Burbank, what's your announcement in Mr. Bernard's case?
Your Honor, Mr. Bernard is on the Spindletop caseload.
Okay.
I think this was set for review today.
Okay, now, Mr. Burbank. Pursuant to Article 1.24.
You're going to make me read the law book. aren't
No,
you?
no, I'm reading. 1.24 of the Code of Criminal Procedure, proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing the disclosure of non-public information, or ensure the defendant receives a fair trial. The court, if we're going to talk about his participation in Spindletop, there may be some disclosure of non-public information. We can close this hearing to the public, and then we can proceed with maybe some of the questions that I might ask that may require.
Whatever the court would like. Your Honor.
Okay, so, okay, let's do this here. So the public, so the court believes that there's an overriding interest that is likely to be prejudiced to the defendant, and the closure is no broader than necessary to protect those interests. And the court have considered reasonable alternatives, and the court has made adequate findings for the closure of this hearing. So at this time, the hearing is going to be closed to the public. We're going to go off of YouTube.